the first to know. Nsem-Pii TV.
Her Ladyship, former Chief Justice, Madam Sophia Akuffo, caused great turmoil for Dominic Ayine, the current Attorney General and a Minister of Justice of the Republic of Ghana, especially in the case of Her Ladyship, currently the former Chief Justice, Her Ladyship Gertrude Isaba Saki Tokono. The removal of President Mahama officially announced say after prima facie case by the Justice Parliament Committee investigations on recommendations on the aba and say omunji Her Ladyship Gertrude Isaba Saki Tokono as Chief Justice of the Republic of Ghana. Now Adena former Chief Justice from the years June 2017 until retirement December 2019. Former Chief Justice Madam Sophia Akuffo statement about affected or case no in the Ecowas Court of Justice. As Supreme Court or here the case between former Chief Justice Gertrude Isaba Saki Tokono or the Kodom Ecowas Court. Now Ecowas Court determine the outcome of hearing between the Chief Justice and Dominic Ayine or Abuja. Now and Sana Ecowas Court determined na President Mahama at the official announcement by early days of September. Say after Justice Parliament Committee in late August, the recommendations by due say on 3 counts or the Madam Gertrude Isaba Tokono as the Chief Justice of the Republic of Ghana. Now, Yanko first into statements on both sides of the argument Ecowas Court and a statement Madam Sophia Akuffo waba ababeka after Justice Parliament Committee a leak said or could defend Gertrude Isaba Saki Tokono her leadership the former Chief Justice Sa committee na say now how a bit influence the outcome of the Ecowas Court hearing of Her Ladyship Gertrude Isaba Saki Tokono. Now first Ecowas Court, Madam no Edokodom, Her Ladyship Edokodom, July 14, 2025, and omo adjane sa case. But both sides of the argument, these were some of the arguments advanced in the court. The initial application suit number ECW CCJ APP 3235 filed by Chief Justice of Ghana sought a suspension of ongoing proceedings to remove her from office and her reinstatement with full entitlement pending the determination of the substantive matter before the court. Petition way and the Ecowas Court of Justice. Now during hearing, a respondent, that is the representative of the Ministry of Justice and as Attorney General Eka said, 1. Ecowas Court no any jurisdictional authority so mbeti sa case so mo raise jurisdictional objection to be heard first as it pertains to the court's power to determine the request for provisional measures. It argued that the court lacked jurisdiction and that the application was inadmissible since it concerned constitutional matters pending before competent domestic courts in Ghana, including its Supreme Court. Expected argument or raise and say then Ecowas Court here a particular case a domestic court in the Republic of Ghana regarding the constitutional provisions of the Republic of Ghana. The independence of the Republic of Ghana, the constitution and its ability for the court to interpret sa constitution idea or more argue say Ecowas Court no interfere na domestic court already here this particular case, including Supreme Court of Ghana. Respondent also contended that allowing the Ecowas Court to proceed would amount to forum shopping and could lead to conflicting decisions. One of the issues some of the lawyers Omodi arguing say a particular court here a particular case now obi de condemn multiple causes court it may appear as forum shopping utiminya judgment in favor, judgments against in different kinds of courts. In say one court here one case at a particular time. Another argument it was advanced by Dominic Ayine, the Ministry of Justice, and Attorney General. Now, the respondent added that the Chief Justice was duly informed of the petition of a removal and afforded access to relevant documents. Consequently, the ongoing process in Ghana are fully consistent with the procedures established under the Ghanaian Constitution. Another final argument on Sir advancing is that Chief Justice Sir petition here at Supreme Court na Nina no almost survey no inti ene te say some form of sham case be normal here. Normal na out seven normal man access to documents petitions Nina almost level against not Chief Justice in a response and otherwise say the applicant argued that the case does not involve constitutional interpretation and yet a matter of constitutional interpretation, rather a clear violation of human rights, one guaranteed under regional legal instruments, cited breaches of Article 5, right to dignity, Article 7, right to fair hearing, and Article 15, right to work. Say ne juma wa bre no ho enya no ena obidi otan epesere oji efri nisem with no just cause. Some of the arguments of the Chief Justice were the Ecowas court around July 15th. Now, of the African Charter on Human and People's Rights. African Charter on Human and People's Rights protects each and every African citizen on the right to work, right to fair hearing, and a right to dignity. Chief Justice at levels are arguments and say, and yet a matter of constitutional interpretation, a matter of these three issues. Now, secondly, the applicant further argued that the proceedings in Ghana had already inflicted reputational harm on her and compromised judicial independence. She stressed that allowing it to proceed could render the substantive matter before the Ecowas court moot. Even though at that time, now Omun determined say oil guilty and as only guilty. Oshe the way the case was handled, I'd say the reputation has been thrown to the dogs. Into a idea or pet some form of compensation for reputational damage. Acquire the Ministry of Justice, the Republic of Ghana, handle this particular matter. Now on jurisdiction, applicant in the site say Ecowas court jurisprudence no affirming the court authority to hear human rights claims despite ongoing domestic proceedings, particularly when the domestic remedies are ineffective or the violations persist. In terms of jurisdiction, I say the Ecowas court will mean say obetie particular cases are affected the domestic human rights of persons in as much as domestic court here say particular case also raises even as cases na also with Justice Parliament Committee na there was side issues of human rights being abused into and the raises Ecowas courts no to me say still here on this matter. The applicant pointed out that the purpose of the application for provisional measures was temporarily to protect her rights and prevent irreparable harm pending the final decision of the substantive case. The matter has been adjourned for a ruling at a date to be communicated to the parties. Indeed, these were the arguments advanced at the Ecowas court. Now, Madam Sophia Akuffo and Awaba into the mix. Surprisingly, Council of Elders or as a committee, they determine a prima facie case. My president recommended this case to the Justice Parliament Committee. But who said it was an overwhelming majority our Council of Elders or abstaining here. So documentation in a leaky say Council of Elders no one supported the argument to say there was a prima facie case against Chief Justice Gertrude Sabasaki Tokono. Now, former Chief Justice, I expressed deep displeasure with the committee which probed the petition that led to the removal of the Justice Gertrude Tokono as Chief Justice by President John Dramani Mahama. After Justice Parliament Committee, almost submitting report to President Mahama. Chief Justice, former Chief Justice Sophia Akuffo abeka se oni omo enye dey enya adwene kra na n'ani nje ekwan a omo fa so eyi omo adwuma. Na some of the arguments or raising say one omo yede omo ko pie mu e wo committee na se ekasaye emma the petitioners against the Chief Justice get to check it no in-camera proceedings na protect omo hide omo identities amfa omo ambechire bodwem. Nanso ono a okopie mu as one of the witnesses and as a defendant okasa ama Chief Justice Gertrude Saki tokono no omo yi ni pie living to the dogs say go bia nhwe Chief Justice Gertrude Saki tokono ye ba bi no na Sophia Akuffo nante baha se oba be akasa man owia no wasa so akwakotena Council of Elders meeting ase so advise President Mahama and okase na when who say media persons bia agada wo inti oblemu members of the Justice Parliament Committee say omo and omo ye omo leaking information say ono oba be attending an in-camera proceedings Ebabe Eden defended the integrity and I say the innocence of her former Chief Justice Gertrude Saki Tokono. Ono na moyi ne pie say oyede obekasa emano. Now on particular concern to her is the leakage of her appearance before the committee, which according to Article 146 of the 1992 Constitution must conduct the probe in camera, thereby keeping the proceedings out of the public eye. Social media and mainstream media were splattered with multiple articles and commentaries about the retired former Chief Justice and former Supreme Court judges appearing before the 5-member Justice Gabriel Parliament Committee to testify in favor of Justice Tokono. Into judges, Chief Justice na Supreme Court judges omo PM omo testify on behalf of Chief Justice Tokono na omo ye PM social media no be ehun say we mo and ebe testify on behalf of Justice Tokono. And omo say in camera na omo ka se bibia in camera no how fair, how true, how just was it? And no statement of Justice Sophia Akuffo our raise here say another clear example of bias and as a possible bias and unfairness on the reason Ecowas Court of Justice. Now, prior to Madam Sophia Akuffo and others' appearance on behalf of the fellow judge, there was literally nothing about the identity of the individuals who appeared before the committee to testify on behalf of the petitioner Daniel Ofori. Inti bon kokasama petitioner ni na obia enim nkrofo testify on behalf of the petitioner. Now so ono any judges on kokasama Chief Justice Gertrude Tokono obia enim said these are the judges, these are the identities of one amko testify on behalf of Justice Gertrude Tokono. And I say where is the fairness, where is the justness, where is the truth? And some matter say case is supposed to be in camera. Now, TV for any in kobo no raise the similarity of this case in a J. Chum case. Now, you check the facts and judgment of the J. Chum case. You are near Kotie Justice Sophia Akuffo ne allegations or level against Justice Parliament Committee. You believe it's a very strong testimony in the Ecowas court, human rights abuses Justice Tokono here in that particular court. Now, facts of the case, like I said, J. Chum versus the Attorney General versus Akwete, a petition was filed for the removal of the Supreme Court judge. The facts that came to light were: one, petition for the removal of the Chief Justice was extensively published to the public. Where one, just like Chief Justice Gertrude Tokono, the also petition, even though it's supposed to be in camera, now it was splattered all over social media in public. This was done in violation to Article 1468 of the 1992 Constitution of Ghana, which stipulates that all proceedings under the article shall be held in camera. That was the first factor, a PMO, in the AJ Chum case. And a plaintiff in the case, AJ Chum, sought a declaration from the Supreme Court that the publication of the petition was unconstitutional and sought to prevent the proceedings from continue. Based on the fact, say a breach, say Article 1468, of the Constitution, or say due to that publication, Supreme Court for any declaration, say publication here unconstitutional, and the proceedings now, a man end twice. Now, second defendant objected to the composition of the Supreme Court panel, arguing that the Chief Justice, who had empaneled the court, had an interest in the outcome of the case, and that is the violated rules of natural justice, especially the principle of nemo juris in causa sua. No one should be a judge in their own case. Chief Justice of the Anna case ne efano on one so the judges are on that particular case. It goes against the principle of nemo juris in causa sua. Nipa yedi case ne eba no what to me away in Crawford or more than name. Now, so judgments of the court and the say 1. Breach of constitutional provision. The court found publication of the petition to the public in a violation of Article 146(8) of the Constitution. Validity of the petition. Despite constitutional breach, court only decided to say petition itself is still valid. Now, it was noted that the publication was not caused by the petitioner. Therefore, the entire process should not have been annulled. The court suggested that damages could be an adequate remedy for the constitutional violation. Where one of the issues Chief Justice Gertrude Tokono, and I said the former Chief Justice Gertrude Tokono, raised Ecowas courts due to the publication of the petition, a court to reputational damage to her person. A buying interest and pacify. Now the role of the Chief Justice in empaneling judges on the Supreme Court, some can say a administrative capacity, not a judicial one. Just because one panel judges does not mean that the judges in their own right thinking capacity intimate and settled on that particular case with jurisprudence and as an independence. It is based on the administrative capacity and not judicial capacity and affected our principle of nemo juris in causa sua. Chief Justice, former Chief Justice Sophia Akuffo, the issues are raised here, I believe affected the proceedings of the Ecowas courts hearing Justice Tokono and the government of Ghana, and as Attorney General Dominic Ayine Akopie Ewo Abuja.
Occupies the position. It is the institution. That is what I'm concerned about.
I mean, what informs the conclusion that it's an unnecessary process? I mean, we have heard even government spokesperson make the point that a petition was sent, a committee in line with the Constitution was set up, they've looked into the matter and they've come to a conclusion. Which aspect of it, what specifically makes it unnecessary?
I think that, you see, there has always been something wrong with Article 146. And particularly with the procedure that it sets out, and especially as it regards the position of the Chief Justice. In the Ajay case, I took the opportunity to reflect on that weakness that I noticed. And unfortunately, what one saw wrong with that procedure as set out is what has come to pass. Because one, it's a provision that sets very vague criteria for or very vague grounds. Misconduct. Misconduct. I hear you're a lawyer. Misconduct ranges. There's no particular description of misconduct. Your child can misconduct themselves in school by chewing gum. That's misconduct. Chewing gum in court could be labeled as misconduct. Misconduct simply means that somebody, in somebody's view, you have misconducted yourself. There has not been, it's one of those standards, if one could call it that, which is incapable of any definition, and to a very large extent it is personal, it is circumstantial, it is dictated by so many things, and one needs to be extremely careful. But that aside, well, and then incompetence is also another vagueness, because incompetence, it could be you didn't know what you were doing, but one should go beyond you didn't know what you were doing and go to consequences of it, etc., etc. And then, of course, there's the third one is infirmity, which I could be, one may say, the only possibly objective ground in that provision. And one had always, certainly when I was Chief Justice, I was walking on tiptoes. When am I going to be accused of misconduct? When am I going to be accused of incompetence? And are these and these are not so, to me, they lack the gravity. They lack the gravity that would lead to a grave outcome, such as the removal of the head of an institution of justice. I've deliberately phrased myself that way. It trivializes the position, and I wonder what this is going to lead to further on along the line, because every judge is fair game and every Chief Justice is also fair game.
I mean, is that to suggest that you